Okay, we are going to move on to our next presentation. This is about the illegal residential uses enforcement strategies update. Now, I know this is something that everybody's been looking forward to, and it's been a very high interest in our community about how we're going to get through enforcement. So in response to the long-standing concerns in the community, the Planning and Community Development Department has been developing and implementing a coordinated strategy to address current illegal units within residential districts. This strategy acknowledges the complexity associated with the enforcement of the adopted regulations and is focused on the implementation of three key elements: the adoption and implementation of the town gown program, the implementation of the rental registration and safety inspection program, and in the enhanced enforcement to identify and bring into compliance, where possible, illegal units. This update is to provide a status on all these efforts, and I'm going to turn it over to Rick Sepler, our Planning and Community Director, and I hope I didn't steal all your thunder.
I just want to say a couple words before we start, because Rick would never toot his own horn, so it's always good for his boss to toot his horn for him. I know there's a lot of concern that people in the neighborhoods and across the city have, believing that there are a lot of violations and wanting to know what we're doing about it. And I want to give Rick some compliments on approaching this in a very professional and data-driven way. I want to make sure that we're out there making sure that the people that are living in our community are living safely, and that our neighborhoods are not having to experience a lot of disruption or the kind of illegal use that is not, well, it's not Bellingham. We like to enforce the law. So I want to give Rick, sometimes doing it well means it comes together a little bit more slowly, but I'd rather have it done right than quickly. And I think now that we have a plan in place, people are going to see more differences and get a different response because we've got our resources in place and we've got things identified. So I'll thank all the citizens who keep us on our toes, and I also want to thank our planning director, actually our community development director, I'm changing your name now, for taking this very seriously and making sure that we're doing the right and the good job.
I'll start by thanking you for the kind words, and on behalf of my department, they're the folks who actually are doing the work that I am privileged to present today. As council might recall, I was before you a couple months ago. We talked about the responses we're preparing to address an issue that's been longstanding in the community, and significant concerns have been raised regarding it. As we look at that issue, there really are two key components that keep resurfacing and have been available before you for a number of years. The first is dealing with illegally established dwelling units in our residential districts, and the second is issues in terms with occupants of rental facilities that exceed our family definition as defined by the municipal code. So I'm going to start off with what we're doing now and then talk a little bit about some of the things that will be coming forward within the first quarter of next year and give you a progress update on that. Enforcement on land use regulations primarily is voluntary. Unlike other regulations where you might go out and do enforcement for like speeding or other things, looking for it on patrol, we count largely on folks to comply based on a voluntary basis, and for the most part, folks do comply. However, there are folks who do proceed to do actions that aren't consistent with our adopted rules, and we rely, as most cities in Washington do, on a complaint basis with which to address those. Each of the complaints that come in are investigated by our staff. We review them point by point, and we try to determine the specific issues, get the fact pattern, and get to resolution on it. I will say that it is very complex. There are no singular fact patterns that are evident for every property. Each one is unique, and we need to sort through both its provenance, when it was established, and its occupancy. Many things are cited in things we hear from members of the community and others that seem conclusive to them. You know, the presence of certain cars that are there, lights being on, things of those nature. While those are facts that we consider, they're not conclusive and would not allow us to proceed to closure on that. We have to dig a little deeper because they aren't by themselves sufficient to move forward. In looking at that, we have done about 332 cases this year so far to date. Of those, to be fair, about 100 of those are not dealing with the two issues before us right now. They deal with folks that have expired permits but haven't gotten final occupancy permit, final inspection. That's a pretty common problem you deal with. And looking a little deeper, some of the things that bubble up, 60 of those were, 64 of them actually, were dealing with rental registration. I'm pleased to say we've been able to sort through all of those 64. So those are folks that were identified as having rental units that haven't registered with the city as part of a registration inspection. That was a key priority of council, and we can report back that we've resolved all of those units themselves. About 17 were dealing with vegetative encroachments, a pretty common thing you hear that come across our desk. And I think we have all but 3 open of those. We have received to date about 13 illegal rental complaints. That's this year. And of those, 9 remain open. We continue to investigate those. So in a sense, we do follow up, and we follow up with some good focus on these, and we tend to resolve them as they move forward. At that point, clearly, we haven't achieved the identified end, which is to address some of the behaviors and some of the uses that are out there. And we said we had to find a new toolbox, a new kit of parts that we could apply that would address it. So we are in the process of doing a number of items that we think will significantly enhance our ability to enforce the 2 issues that we identified at the beginning, the illegal units and the definition of family. The first is, while we've had code enforcement present in the police department to enforce our zoning, it's always required planners to go through that unique fact pattern and get those facts that could allow them to be enforced by the folks in our police department. We've done that sort of as an add-on to the roles of many of our existing planners. And the challenge on that is when it's not a focus, it's something you get to when time is available. We took a look at a number of the positions we had available, and were able to combine a number of part-time positions, council might recall, and to allow for a new full-time planner whose primary focus will be to follow up on these investigations, to dig down, using new technologies, and to further enforce the code itself. Those new technologies are something that we bring to bear. We're able to use our GIS analysis, I think I've mentioned before, as well as an analysis of rental registration as compared to our existing zoning. And we can identify properties that may not be in compliance with our code and follow up on those specifically. And we hope to do that. Additionally, and I should say there isn't one magic bullet that's going to allow a higher degree of enforcement to occur. It's a bunch of separate, discrete actions taken together that reduce the number and size of the problem. We are going to bring forward an amendment for consideration to council to modify Title 20 to change the violations from criminal to civil. And the reason for that is Title 20 does not clearly state that the property owner, tenant, property management company is in violation of the law if more than 3 unrelated folks are resident on the property. This would allow us to fine those individuals, which will give greater accountability and allow our enforcement to be much more efficient. Additionally, we'll be bringing forward an ordinance that will require the number of bedrooms and occupancy limits to be listed on advertisements and listings for rental properties. This was brought to our attention. It's used in Boulder, Colorado, and it's a very effective means to establish a clear understanding of the specific number of individuals that are allowed in a unit. Additionally, we have and will require in the next round of rental registration applications that the number of bedrooms be indicated on the rental registration app itself, as well as posted in the units. And again, it was brought to our attention. This may be a good process that could allow us to get clear information out to future tenants and how that would work. We are also working to advance the town gown program, and that town gown program is a very significant way of dealing with a number of the issues identified. I will say that education is the key component to help change behaviors and change characteristics. If folks know that a use is not allowed, and those are potential tenants, they're disinclined to enter into that use, especially if they know enforcement is fairly rigorous on it. The Colorado State University experience, as you recall, we received a grant. We sent folks out there. It was the best program we could find in America. Spent 2 years before they went into very detailed on-site code enforcement to develop education in the community. We're going to try to pair continuing efforts on code enforcement, not wait 2 years. But we understand that education, that's how important the role is. You got to get the message out. But within 3 years, they were able to change culture, and we think that's a great outcome. We've had good traction on town gown program. We had a very successful meeting with 2 vice presidents from Western on Friday. They are very supportive of the end, and they're supportive of their role to bring together resources to provide good education for their students, for example, before they're out into the community and looking for accommodations. And I think that's a good step in that direction. We should have something again in the first quarter coming forward. So, our next steps: train the planner, starting on the 3rd of January, who will support enforcement. They will not be effective on their first day, but we'll certainly be working to get them effective as soon as possible to follow up on those issues. Follow up on all of the code enforcement complaints that come in. We have a good track record of doing so. We will continue to do so, but with new tools we could bring to bear that might get better resolution, because as you know, we're so easily stymied by some simple actions taken by those who wish to thwart our code. We'll use our new data and analysis and contact the owners of those units that appear to be illegal, and we'll follow through on each one of them till they're resolved, determined to be legal in compliance or not. We'll bring forward the proposed ordinances for your consideration, and we'll work cooperatively with Western to complete and implement the town gown program. I should note that the ordinances will probably be brought at about the same time as town gown. We'll try to bring it all together because it makes most sense when you see them all as a package rather than sort of incrementally. I'd be happy to answer questions you might have on this matter.
Councilmember Hamel.
On slide 4, you indicated that there were potentially fines for the individuals that live in the unit. What tools are there to hold the landlord accountable?
That's what the changes would do. You're hitting the nail on the head. Our problem now is that in many cases, the experience we found, first, there are civil penalties, civil infractions, which are a higher standard and difficult to establish a fine. And secondarily, often there's a master lease that's provided, and the management company or property owner says they had no knowledge of the occupancy of the unit. And in essence, we can, once we do investigation and find out indeed it is in violation, all parties may be subject to fine. It'll be detailed in the ordinance for consideration.
Councilmember Borneman, then Lundquist.
Yeah, this isn't a question. This is a compliment. I wanted to commend you on one of the units that had brought forward to you and neighbors had brought forward to the to your department about illegal adding of units in one of the houses. I see there's a beautiful red and black tape across the front of it shutting it down. And so I do commend you for following up on that and shutting the place down until they make the improvements in a legal way that are required instead of just the way they have done it. So it's good to see that the department is following through on some of those and
I'll pass that on to the folks who actually do that work, and we're leading the edge in making that happen.
Councilmember Lundquist.
Thanks, Mickey. I also want to offer a compliment. I support the idea of new rules and requirements to accurately report the number of bedrooms that are allowable. I think that's been an omission. It's made our job difficult. If people don't accurately report how many units or bedrooms are available in a unit, how can you hold them accountable for misstating it? I also want to praise the idea of a full-time planning position to work on these issues. I know several years ago there was talk that maybe we could solve this problem with existing resources, and that never struck me as realistic, that this really would take some dedicated time. As you say, if it's only one of your jobs on your list, then it's only got to on a very inconsistent basis, so I really appreciate that. And overall, I think you said it yourself, we're taking this seriously, and these issues have been long-standing. And so I'm very glad, and I think it's fully appropriate that we do take this issue seriously. Thank you.
Councilmember Barker.
When you bring forward the potential changes to the Rule of Three going down from it was a criminal to a civil, is that what I heard?
It's a change in 20 to deal with these kind of infractions. Right now, as criminal, they're very difficult for us. We don't, as I understand it, and Peter can speak to it more specifically, it's difficult to make the burden of proof is different. We haven't cited exactly what the violation is. This provides a clarification under civil. Peter, did I get it half right, I hope?
Yeah, I agree that I think that's an accurate description. In some respects, for example, with the rental registration ordinance, we basically cast the net fairly broadly, and anyone who's responsible for the illegal activity, and to identify the responsible individual is an important aspect of that for any sort of violation, and that would be part of it, really looking at that as well as making it a civil infraction.
Well, go ahead. Go ahead. No, I just want to thank Rick for taking this on and really following through with it and bringing it forward. I think we're way ahead of the game. And to you and your staff, thank you. And when you first came here, this was dumped on your lap, and you have done a great job. So thank you very much.
Go ahead, Councilmember Barker.
So I've tried to look up the history of the Rule of Three, or no more than three unrelated persons, and it seems like it was decades ago when we had different social norms. And I'm wondering, as you bring that back, if that's something that the council would like to discuss further, if that's something that's still within the social norm that we'd like to continue having this ordinance on the books, or if it's something that there might be something that gets at what people are wanting from that ordinance that's easier to enforce but doesn't discriminate against people who might not be living in a related relationship by the law.
What I can say is there have been substantial changes in the nature of family in America, and I think it is likely that a discussion will happen before this body, a policy discussion on that issue at some time in the future. The Rule of Three is that cities have the ability, cities and other jurisdictions that provide zoning, to establish a limitation on unrelated people. That was upheld by the Supreme Court in the Belter decision. That was one where a group of Penn State students were living together as a family unit. And the Supreme Court in the split decision did say to preserve the sanctity of the neighborhood's character, cities have the ability, as well as other jurisdictions that have zoning power, to regulate family. I do think we do need to discuss that. And the reason for that is the changing nature of family itself, and I think it will be one that we probably should look in the next year or so. It doesn't affect our enforcement efforts in this program, but it is something that inevitably we'll have to address as our communities change. I'm reminded that the nuclear family, mom, dad, and kids, is the minority in America now, that most families are quite different.
Councilmembers Murphy, then Lillquist.
Yeah. To take it a little further, I feel like our community problem is overcrowding in residential units, and that's the bigger issue versus trying to prove whether people are related or not, or get to the bottom of that. So I would love an effort more focused on, and that's why I love seeing that we would have a declaration of how many bedrooms there are and what the occupancy would be. That's more what I'm interested in to deal with the overcrowding issue.
Councilmember Lillquist.
Just an observation. Our definition of family is very broad. Aunts, uncles, cousins, nephews, nieces, anybody and everybody who is considered part of the same very extended family. And you can also have unrelated member living with you as well. I mean, it's a pretty broad definition right now of what we allow in single-family areas.
Councilmember Hamel.
Just to have a sense of item 3 there, what is the penalty for the civil infraction? Do you have a sense of what that range would be?
That will be up to council ultimately. I believe in the rental registration ordinance, the civil infraction, I think for the first offense was a $250 penalty, if I remember correctly. And sometimes then you increase the penalty if you don't get compliance. And there's different ways to approach it, but that's ultimately for council to decide.
Thank you.
Council members, any other? Okay. I do want to add to that, thank you, Rick, for taking this on. And I know it's been really, really important for the people of Bellingham that enforcement is something top of mind. And so I think they'll be happy with some of the changes that we're making. And of course, that won't happen overnight, but we are heading in the right direction. So thank you to your entire team for implementing all of these things.
If I might just follow up and thank you for the kind words. What I would say is that we move very carefully and deliberatively because our burden of proof and the facts we need to assemble have to stand very close scrutiny. And quite frankly, I'm sure you'd all agree that's what you want government to do, not rush to judgment. That may, to some degree, frustrate some folks who see us take time on an investigation, but I think that's intrinsic to the nature of how we want our governments to act and be very thoughtful, considerate, fact-based, and then come to conclusion and not rush to judgment. So that's the way we're going to proceed, I think, and I think it models ourselves on how we perceive ourselves as a city. Thanks.
Thank you, Rick. Everyone else? Okay. Thank you. And that was for information only.